Are you a police officer? Do you have to prosecute some of your own cases in court and have no idea what you're doing? In this video, I'm going to teach you how to avoid 3 common mistakes that I see officers make when prosecuting their own cases. Hi, I'm Erik Scramlin with Tactical Legal Solutions. I've been a prosecutor in New Mexico for 10 years, and in that time, I've witnessed police officers that make 3 common mistakes when prosecuting their own cases. When I would cover the magistrate court here in New Mexico, I'd often see officers kind of get that deer in the headlights look when the judge would call their case or the defense attorney would object to a statement that they made during the trial. So in this video, I'm going to talk about these 3 common mistakes that I've witnessed over the years that I see officers make when prosecuting their own cases and how you can avoid them. But before we get started, please consider hitting that subscribe button. I've just launched my new training courses specifically for law enforcement officers, and I'm going to be putting a ton of content right here on this channel. So please subscribe so you can stay up to date and take advantage of all the free stuff that I'm going to be posting here. Okay, let's dive right in. Number 1, failure to disclose evidence. The first common mistake that I see officers make when prosecuting their own cases is right from the beginning, they fail to disclose evidence to the defendant. Brady v. Maryland was a landmark Supreme Court case that requires the prosecution to turn over all evidence that might exonerate a defendant to the defense. It's known as exculpatory evidence. Now, most states don't have a requirement to turn over all discovery in traffic citations and misdemeanor cases, but here in my state of New Mexico, you have to turn over everything. So it's Brady plus extra stuff. And what I see officers do is they disregard the letters that the defense attorney will send them, or they just fail to turn anything over to the defendant. Then they show up for trial, the defense attorney makes a motion, and then the judge dismisses the case because the officer didn't disclose any evidence to the defendant prior to trial. Avoid this mistake by getting organized and getting organized early. So every time that you write a ticket or file that complaint for a misdemeanor, start a folder and put your discovery in it. So I'm talking about your complaint, your body camera, any photographs you've taken, everything. This could be a manila folder. It could be a notebook that you put together. What I recommend though is using a program called Evernote. Evernote's a great tool for organizing cases and it's free. I'll leave a link for it in the description below. Now, by organizing your cases and getting organized very early on, you can engage in that discovery process right from the beginning at the pretrial conference and get it out of the way. The last thing you want to do is wait to the last minute, because if you wait to the day of trial and try to turn all that stuff over, the judge may ding you for a discovery violation. So get organized and get organized early and get your discovery turned over to the defense attorney. Number 2, failure to prepare for trial. The second most common mistake that I see officers make when prosecuting their cases is they show up to court completely unprepared to do a trial. So the officers work the night shift. It's 8:30 in the morning, they're tired, they're still in uniform, and all the officers brought with them is a copy of their citation, a copy of the report. No body cam, no radar certification, no copy of the records from motor vehicle that proves that the defendant's license was revoked. So what happens here? Judge calls the case, the officer comes up to the podium and just starts telling the judge what happened. The defense attorney stands up, makes an objection to hearsay, the officer gets the deer in the headlights look. I often teach officers in my officer prosecuted course a quote from The Art of War. All battles are won or lost before they're fought. Meaning if you show up to trial on the morning of trial at 8 o'clock in court and you have done no preparation for your trial, then you've likely already lost it. You have to put in the work ahead of time. You have to spend time preparing that case for trial. Now, I don't have time in this video to go over how to do an opening and a closing and a cross. I have other videos on that. You should definitely check it out. But if I could give you one piece of advice or one thing that you could do in preparing for your trial that'll put you light years ahead of some of the other officers that I've seen out there, that is to take your case and develop a story or a theory to tell the judge why the defendant's guilty. You don't just want to go up there and just recite the facts to the judge. Instead, you want to build your case into a story because good stories wins trials. So at the very least, take the time to develop some facts so you can present your case as a story to the judge. Number 3, relying on hearsay to prove your case. This is a very common mistake that I've seen officers make, and it's really hard to watch when it happens, because this is the officer that shows up who didn't engage in the discovery process, didn't bring any evidence with him to court, isn't prepared to do the trial. So the officer gets on the stand, starts testifying, says, "Your Honor, dispatch advised me that the defendant's license was objection, hearsay," and then the judge sustains the objection because it's an out-of-court statement offered for the truth of the matter asserted. The officer didn't bring his letter from motor vehicle department to prove that the defendant license was in fact revoked. Instead, he was relying on this statement from dispatch, what the judge has now ruled as hearsay, and the officer doesn't know what to do. And he can't proceed with the case, so the judge finds the defendant not guilty at this point, and the case is over. Okay, so how do we avoid this? We avoid this by listening to what we talked about in common mistake 1 and 2. From the very beginning of your case, you have to get prepared early on. Get that discovery in your case folder. Disclose it to the defense. Prepare for trial. Bring the evidence with you to court. You want to give that evidence to the court. You want to use that letter, that hard evidence to prove your case. You don't want to rely on these out-of-court statements that the judge, more likely than not, is going to rule as hearsay. So be prepared, get prepared early on, rely on the evidence at court and not out-of-court statements. So there you have it, 3 common mistakes that I see officers make when prosecuting their own cases. If you found any value in this video, please consider hitting that subscribe button and contact me if you or your department is looking for officer prosecution training. I offer a full officer prosecutor course where I'll teach you everything you need to know about how to prosecute your own cases, including how to do a trial. You can find more information at my website at tacticallegalsolutions.com. See you next time.